Welcome back. In this case, we take up the story of national origin discrimination. Discrimination based on national origin. Now, we're not going to spend a lot of time focusing on the basics of discrimination law because we've already touched on that when we talked about race and color and sex discrimination, things like the prima facie case. But there are three trends in regard to national origin discrimination that I want to focus on in this case. And the first is that national origin claims are increasingly brought as race claims. Now, to go back to our discussion of Title VII, the framers of Title VII, the people who wrote Title VII, when they talked about race discrimination, invariably they were thinking about black and white. Title VII came out of the civil rights movement, and that was the focus of the drafters of Title VII, was black and white discrimination. Everything else was supposed to fall into the category of national origin claims. But of course we know that race claims receive the most intense scrutiny, and there's no BFOQ available for race claims. And therefore, what we've seen in the past few years is an increase in the number of national origin claims that are brought instead as race claims. We also see language claims brought as national origin claims, and we'll talk about the three types of language claims that arise. And the final trend, we're not going to spend a lot of time on it, but you should know that national origin claims are frequently now alleging national origin harassment, just as sexual harassment claims, that a hostile work environment was being created based on national origin. So in this lecture, we're going to look at national origin discrimination under Title VII. Now we know that Title VII prohibits employers from discriminating against employees based on the national origin of the employee. But like so many things in Title VII, national origin is not defined. What do we mean when we say national origin? Now the Supreme Court has essentially interpreted national origin to mean geography. What part of the world did your ancestors come from, or what part of the world did you come from? So geography. But of course that's pretty limited, and what we've seen in the rest of the court system, especially by the EEOC, is that discrimination against a national origin group includes discrimination based not just on geography, but ethnicity. What is your ethnic background? Things like physical or linguistic or cultural traits. Perception. What do other people see you as? That even if you're not Hispanic, but if other people see you as Hispanic, then that may give you status to bring a national origin claim. 1981, remember talking about race discrimination? Courts have actually split on the issues of whether you could bring a national origin claim as a Section 1981 claim. And right now there's not a consensus. In some federal circuits, you can bring a national origin claim as a 1981 claim, meaning we're going to conflate the notions of race and national origin to provide national origin as a remedy under Section 1981. Other courts say no, that race is distinct from national origin and the statute says race, and therefore we're not going to shove them together. If Congress wants to change 1981 to include national origin claims, then they can do so. So right now, national origin sometimes can mean the same thing as race, but sometimes not. Now, national origin discrimination cases are resolved in the normal manner. You make the prima facie case, those four factors: that you belong to a protected group, that you were qualified for the position, that you suffered an adverse employment action or was denied employment benefits, and that other similarly situated employees not in your protected class were treated more favorably. And again, the defendant employer responds with either LNDR, legitimate non-discriminatory reason, or BFOQ. And again, legitimate non-discriminatory reason is always going to be your best response, your best defense. The action that we took had nothing to do with national origin. National origin can be a BFOQ, can be a bona fide occupational qualification. It's fairly limited. It's not as limited as, say, a BFOQ for sex. And of course, BFOQ is not available for race or color. But you have to show that the national origin of the individual is related to the job that it is that you are seeking. So if you have say you've got a French restaurant and you want to have the most authentic experience available, and you decide that you must hire a native French person as your head chef, you could probably do that. You could discriminate against those born outside of France under the theory that I need a French chef. Now, could you do that with your wait staff? Much harder to say that, because in fact, the wait staff, the job of the wait staff, may have very little to do with ethnicity or national origin. And so in that case, probably not. For those positions, back of the house positions like busboy and line cook and janitorial individuals, almost certainly you could not establish a BFOQ, because those jobs have nothing to do with the national origin of the person doing it. So BFOQ is available, but really in limited circumstances. Customer preferences can never be a justification for discriminatory practice. That you cannot discriminate again in the hiring of employees based on what you believe your customers expect. We know it happens, we see it happen, but it's not legal. Now, discrimination can occur even where the victim and the person who inflicted the discrimination are of the same national origin. And we go back to that same idea of, is a person of this national origin being treated differently than a person of another national origin? In this case, Kong versus ULIM America. ULIM America was an American subsidiary of a Korean firm. And many of its workers, about 2/3 of its workers, were Korean or ethnic Koreans, Korean Americans. And then 1/3 were not Korean. Now, one of the supervisors, Mr. Kong's supervisor, was Korean. And he believed that Koreans should be held to a higher standard. That Koreans are going to be expected to work harder, to do better, to be more productive, to take criticism better, to abide by what they're told, to follow orders better. And so in this case, the supervisor believed that Koreans were superior to non-Koreans in these areas. Mr. Kong was subjected to routine harassment from his supervisor. He would call him names. He would carry a ruler around and whack him on the hand. And eventually, Mr. Kong filed a lawsuit for disparate treatment. I'm being treated differently. Now, the argument from the employer is they're the same ethnicity. Therefore, this person is not outside of the same protected class as the employee, as the plaintiff employee. And what the court said again was the treatment is being based on national origin. That those who are not of Korean ethnicity were not confronting the same problems that Mr. Kong, a Korean American, was suffering. So on your case, just know, or on your test, remember that just because they're of the same ethnicity doesn't mean there's no discrimination occurring.